Exempt to be learning with you on a Tuesday night. So it's Yom Revi'i. Let's light up the darkness. Who's in the house? Stephen in New Hampshire, Paul in Chicago, Paul in the Great Northwest, Bill in Mid-Missouri, Lucy in Minnesota, Bella in Florida, Melissa in Great Neck, Shandor in the Bronx, Joe in the Inland Empire, Joseph in Massachusetts, Sharon in Massachusetts, Jonathan in Ventura County, Karen in Northern California, Marjorie in the house, Chaim in Florida, Ella, Lynn in Maryland, Aoife in Florida. Welcome, everybody. Tonight's episode, the AT Daily, sponsored by Sammy Rana in honor of his mom. A beautiful dedication. Sammy, may you and your mom and all your loved ones be showered in blessings. We say amen. Thank you for enabling us to share more Torah with more people around the world. So grateful to everyone who has already stepped up. We appreciate it more than you can imagine. Keeps the lights on. It helps us to do all the programming. The app is getting very close, but, you know, just like the movie, you can build a house in a month. You got a house. But all the finishing details so that you can live in it, the doors, the locks, the faucets, all that stuff takes a lot of time. But we're getting close. Problem is, you know, all those last tweaks working with the app developer, expensive. Our coffers are low, so to speak. So we really appreciate everyone supporting our nonprofit at donate.accidentaltalmudist.org. Let's get into it. Our daf tonight is page 47, continuing, and we're going to conclude, God willing, our discussion of Mishna number 1 here in chapter 5 of tractate Bava Kamma, the 21st volume of the Talmud. Mishna number 1 here in chapter 5 was dealing with this ox that gored a cow that recently delivered a stillborn fetus. It might have been because of the goring. It might not. That's the issue, the uncertainty. And also a cow that gores an ox. And it's uncertain whether the fetus was inside the cow at the time that it gored the ox or whether it had already been delivered, and that affects how much damages we can collect since it was an innocuous cow, and so the damages are limited to the body of the animal that caused the goring. Okay, we pick this up near the top of page 47a, and Rava also says, when assessing the damage inflicted by a goring ox on a cow whose newborn calf is found dead by its side, the court does not appraise the damage to the cow by itself and the damage to the offspring by itself. Rather, the court appraises the offspring together with the cow and evaluates the overall damage inflicted on the pregnant cow, which will be slightly less than it would be if the court conducted two separate valuations. And the reason for this is that if you do not say this, you will be found to have ultimately weakened the one liable for damage, meaning you inflict a loss on him beyond what the law calls for, as the market value of a newborn calf is greater than the difference in market value between a pregnant cow and one that is not pregnant. And similarly, you find this principle in a case where someone did an action that resulted in the loss of a hand of a person's slave, and the difference in value between a slave with a hand and a slave without a hand is assessed, rather than determining how much money the owner would request in exchange for allowing the hand of his slave to be cut off. Not, again, one of those examples, it doesn't really come up. No one is going to take money to have his slave's hand cut off. But rather, just to use that as an example to understand the difference between two systems of evaluation. And similarly, you also find this principle in a case where one who causes damage to part of another's field. So the court appraises not the garden bed that was eaten or trampled, but rather the depreciation in value of the bed as part of the surrounding area. And this results in a smaller payment as the damage appears less significant in the context of a larger area. So Rav Acha, the son of Rava, said to Rav Ashi, well, the main reason invoked by Rava is that otherwise you will have found to ultimately weaken the one liable for the damage, meaning you will extract more damages from him to be paid to the injured party. So says Rav Acha, the son of Rava, but if this is the law of assessing the damage, then let the one liable for damage be weakened. So what? If this system of valuation is going to result in the one liable for damages paying a little bit more damages, why should we be concerned about that? Let him pay a little bit more. And Rav Ashi answered, this is because the one liable for damage can say to him, I caused damage to you through injuring a pregnant cow, and so I am assessing the value of a pregnant cow for you. Therefore, it is not correct to evaluate separately the damage to the cow and the damage to the offspring. Bottom line, the system for evaluating how much damages are owed has to be fair. You can't just say that, well, somebody did something wrong, so just stick more penalties, greater damages on him. It has to be fair, and it has to be supported by the facts. And the Gemara raises a question. It is obvious that in a case where the cow belonged to one person and the offspring belonged to another person, that the compensation for the cow's loss of fat is paid to the owner of the cow. The additional value that the cow had due to the fact that it was fatter due to the pregnancy is paid to the owner of the cow. So the question is, what is the law concerning the cow's bulk? There is an increase in value of a pregnant cow that is attributed to its improved appearance, which results from its carrying a fetus. Who is considered the injured party with regard to that sum? And Rav Papa said this too belongs to the owner of the cow, whereas Rav Acha, the son of Rav Ika, said they divide the restitution. And the law is that they divide the restitution. And that completes our discussion of Mishnah number 1 here in chapter 5. Mishnah number 2. In the case of a potter who brought his pots into a homeowner's courtyard without permission, and the homeowner's animal broke the pots. So who's liable for what? Right? So somebody owns an animal, and somebody brought some clay pots. It's a potter, he's a professional, right? So these pots are his livelihood, it matters to him. But he brought them into the property of the owner of the ox without the homeowner's permission. And then the ox broke a bunch of those pots. What do you think is going to happen? Why should the homeowner be liable, right? So in that situation, the homeowner's animal broke the pots, so the homeowner is exempt. If the owner's animal was injured by the pots, the owner of the pots is liable because he brought those pots into the homeowner's property without the homeowner's permission. But if the potter brought them inside the homeowner's property with his permission, then the owner of the courtyard is liable if his animal caused damage to the pots. This is it's a little bit interesting, right? So are you saying that if somebody wants to come and sell me some pots, a salesman, he comes to my house, he wants to sell me some stuff, he says, can I come in? I say, all right, come in. I want to be polite. So he comes in my house and he's showing me his wares. I don't feel like buying it. While he's inside, my dog, gets a hold of one of his items that he's trying to sell to me. I don't have a dog, but if I had a dog, and ruins this item that the salesman brought into my home. So I would be liable to replace the salesman's property because he entered my home with my permission. And so at that point, I undertook the responsibility to keep my animal from damaging the property of this person who entered my property. And similarly, if someone brought his produce into the homeowner's courtyard without permission, and the homeowner's animal ate them, the homeowner is exempt. If his animal was injured by them, for example, if the homeowner's animal slipped on the produce that this visitor brought who entered without the homeowner's permission, then the owner of the produce is liable for the damage to the animal that slipped on that produce. But if this visitor brought his produce inside the homeowner's courtyard with the homeowner's permission, then the owner of the courtyard is liable for the damage caused by his animal to the produce that was brought onto his property. And similarly, if one brought his ox into the homeowner's courtyard without permission, and the homeowner's ox gored it, or the homeowner's dog bit it, then the homeowner is exempt. If it gored the homeowner's ox, the owner of the goring ox is liable. Furthermore, if the ox that he brought into the courtyard without permission fell into the homeowner's pit and contaminated its water, the owner of the ox is liable to pay compensation for spoiling the water. If the homeowner's father or son were inside the pit at the time the ox fell and the person died as a result, then the owner of the ox pays the ransom. But if the ox's owner brought the ox into the homeowner's courtyard with the homeowner's permission, then the owner of the courtyard is liable for the damage caused to the ox. And Rabbi Yehuda Hanasi, Rebbe, says the homeowner is not liable in any of the cases in the Mishnah. Even if he gave his permission for the items to be brought onto his premises, unless he specifically accepts responsibility upon himself to safeguard them. So in the case of my salesman that brings his stuff into my house, I don't really want him there, I'm just being polite, and then my dog gets a hold of one of his items and ruins it, according to Rebbe, I would not be liable to pay for that unless I specifically said, I have a dog, but don't worry, I'll make sure my dog doesn't, mangle your stuff while you're visiting. If I didn't say that, I would not be liable. But that's the minority opinion of Rebbe. Now the Gemara, and we're on page 47b. From the first case of the Mishnah, it can be inferred that the reason the potter is liable is that he brought his pots into another person's courtyard without the homeowner's permission. But if he brought them in with permission, the potter would not be liable for damage caused to the courtyard owner's animal. And we do not say that the potter accepted responsibility for the safeguarding of the courtyard owner's animal from his own pots. Now, whose opinion is this? It is that of Rebbe, who says at the conclusion of the Mishnah that any case where permission is granted to allow an item onto one's premises without specification, meaning without an explicit agreement as to who is responsible for safeguarding the item, it is assumed that with regard to each party, he has not accepted upon himself the responsibility of safeguarding the item with respect to the other people and their property. Therefore, the potter who received permission to bring his pots into the owner's courtyard similarly did not accept responsibility to safeguard against damage to the property of the owner of the courtyard, like that his animal would slip on the pots and get hurt. But say that the latter clause, if the potter brought them into the courtyard with permission, the owner of the courtyard is liable. Well, in this case, we arrive at the opinion of the rabbis who disagree with Rebbe and say that even in a case where permission is granted to allow an item onto one's premises without specification, where the owner merely said that he could bring them into the courtyard, according to this opinion, the homeowner accepts upon himself responsibility for safeguarding the items belonging to the visitor to ensure that they are not damaged. And furthermore, at the end of the Mishnah, Rebbe says that the owner of the courtyard is not liable in any of the cases in the Mishnah, even if he gave his permission for the items to be brought onto his premises, unless the owner explicitly accepts responsibility upon himself to safeguard them. Therefore, it emerges that the first clause and the last clause of the Mishnah are in accordance with the opinion of Rebbe, but the middle clause of the Mishnah is in accordance with the opinion of the rabbis, the majority who disagree with Rebbe. Is this a reasonable way to read our Mishnah? And the Gemara answers that Rabbi Zera said this Mishnah is disjointed, and indeed it does not follow a single opinion. Rather, the one who taught this clause of the Mishnah did not teach that clause of the Mishnah. And Rava said the beginning of the Mishnah is entirely in accordance with the opinion of the rabbis. In the case where the potter received permission to place his pots there, the owner of the courtyard accepted responsibility upon himself for the safeguarding of the pots, and even to the extent that if the pots broke due to the wind, he would be liable. And the owner of the pots, by contrast, did not accept any responsibility to ensure that his items would not cause damage. So it appears that, at least according to Rabbi Zera, when the homeowner said, sure, you can bring your pots into my property, he didn't need to say, and I will accept responsibility in case they're damaged while they're on my property, which Rebbe would require before he becomes liable. According to Rabbi Zera, just inviting it in is like saying that I accept responsibility. So the Mishnah teaches if he brought his produce into the homeowner's courtyard without permission and the owner's animal was injured by the produce, he is liable. And Rav says they taught this law only in a case where the animal slipped on it and fell. But if the animal ate from the produce and was injured, he is exempt. And what is the reason? The animal should not have eaten it. And it was not the owner of the fruit who acted improperly, but the animal itself. And Rav Sheshes said, I say that Rav stated this law while dozing and lying down, meaning it is not entirely precise, as it is taught in a baraisa, one who places poison before the animal of another person is exempt according to human laws, but liable according to the laws of heaven, right? Meaning he didn't take the poisonous food and jam it into the mouth of the animal, but he left it in front of the animal, right? So he didn't force the animal to eat it, but the animal is just, a beast, an unthinking beast. It's pretty foreseeable that he will eat some poison if it's placed in front of it. Nevertheless, what we say is, according to Torah law, a person who places a poisonous piece of food before the animal of another person, there's not a law that specifically covers that in the same way as if you killed the animal of another person. So you won't be punished in an earthly court according to Torah law. But you will be held accountable before the heavenly court, right? So, for skeptics, they're like, oh, that's nice. Your religion says this person's going to get punished in heaven, but there is no punishment for him on earth. Nice system, right? Well, that's what a skeptic says because he doesn't understand the reality of the world that we live in. The reality of the world that we live in is that we were created by God. We were sent here on a mission. We are held accountable for all the transgressions that we do while we're in this world, and we're rewarded for all the good and the commandments we fulfill while we're in this world, and then all of that is balanced. And so when we say that somebody's going to be held accountable according to the laws of heaven, that is no small thing. Likewise, what we've been talking about, the ransom, when, if an ox that belongs to me ends up killing a person and I am liable to pay the ransom, that means that I'm liable to pay the ransom, and if I don't, my punishment is going to be death at the hands of the heavenly court. Do you want that hanging over you? Of course you don't. That's why you pay the ransom, which is given to, the family of the injured party. Okay, where am I? So he can argue that he shouldn't have eaten. And Rav Sheshes said, so one who places poison before an animal belonging to another person is exempt according to human laws, but liable according to the laws of heaven. Now, from the above statement, it may be inferred that it is specifically where he put poison before the animal that he is exempt, since it is not suitable for eating. But if he put produce before it, which is suitable for eating, and the animal dies from eating it, he is also liable according to human laws. Okay, so now what he's saying, like now it's a sharper distinction. If you put a bowl with nothing in it but poison, that is not food, it's just poison, right? So you left that lying around because you weren't really that concerned that an animal would come and eat it, because there's nothing attractive about that poison. In fact, it's fetid, it smells bad, it's not nutritious. Why would the animal eat it? It's a surprise that the animal ate it. But if you have the type of produce that looks like, the kinds of plants and produce and grain that animals normally eat, but it is somehow laced with poison, or it's the kind of produce that this animal wouldn't recognize that it is not similar to what it normally eats, even though it looks and smells similar, but in fact is it some kind of produce that if that particular animal eats it, it's poisonous to it, okay, and you left that lying in front of someone's animal, then that is like killing the animal, and you will be held accountable for that, not only before the laws of heaven, but also the earthly laws, right, in an earthly court. So the Gemara analyzes this ruling, but why is he liable? Here also Rav's logic can be invoked that the animal should not have eaten it. The animal should not have eaten it, but if it looks like the kind of produce the animal normally eats, why would you expect that the animal won't eat it? So in order to explain Rav's statement, the sages said, the same is true, that even if the animal was injured by eating the produce, he would also be exempt according to human laws. And this Baraisa teaches us this, that even in the case of poison, which is not suitable for eating, the one who placed the poison before the animal nevertheless is liable according to the laws of heaven. You shouldn't have left poison lying around where an animal could eat it, even if there was no reason to believe that the animal would eat this fetid, stinking, disgusting poison that is completely unlike what the animal normally eats. Nevertheless, you endangered the animal, and though you might not be liable in an earthly court, you will be liable according to the laws of heaven. And if you wish, say instead that the case where the Baraisa exempts from liability according to human laws the one who placed poison before the animal is referring to an item suitable for eating as well, such as afrasta, which is a type of herb that appears edible for animals but is actually poisonous. Therefore, this herb is legally equivalent to any other produce for which he is exempt from liability according to human laws, since, as Rav explained, the animal should not have eaten it. And the Gemara raises an objection to Rav's statement from a Baraisa. In the case of a woman who entered the house of a homeowner without permission in order to grind wheat, and the homeowner's animal ate the wheat, he is exempt. She came in without permission. Why should she expect that the homeowner's animal wouldn't eat her wheat while she was there, and that he would be liable if the animal did eat it? She entered without permission. Moreover, if the homeowner's animal was injured by the wheat, the woman is liable for the damages to the animal. Now, according to Rav's explanation, why is she liable? Let us say here as well that the animal should not have eaten it. In order to explain Rav's statement, the sages said, what is the difficulty here? Is this Baraisa preferable to the Mishna that we interpreted as a scenario where the animal slipped on the produce? Similarly, the Baraisa is also referring to a case where the animal was injured by slipping on the wheat, not by eating it. So the Gemara asks, and he who asked it, why did he ask it? This answer seems obvious. The Gemara answers, the questioner could have said to you, granted, the Mishnah that teaches if it is injured by them, bahen, is referring to a case where the animal slipped on them, bahen. But here in the Baraisa it teaches the phrase, if it is injured, and it does not teach the additional term, bahen. Since the case is immediately preceded by the case of, and the owner's animal ate them, it is reasonable to surmise that when the Baraisa teaches the case of an animal being injured, the injury is due to eating. The grammar of that Baraisa suggests that we're still talking about the animal being injured through eating, not by slipping on the produce. So the Gemara notes, and the other one, i.e. the one who provided the answer, could have said to you in response, there is no difference whether it states it was injured or it was injured by them, as in both cases the injury can be explained as resulting from slipping and not from eating. come in here a proof from a Baraisa. If one brought his ox into a homeowner's courtyard without permission, and the ox ate wheat belonging to the homeowner, and consequently was stricken with diarrhea and died, then the homeowner is exempt, right? Because the one who brought his animal onto that property did so without permission. But if the ox's owner brought the ox into the courtyard with the permission of the homeowner, then the owner of the courtyard is liable if that ox eats wheat belonging to the homeowner and gets sick and dies from it. And the Gemara comments, why? In the latter case, is the owner liable for the damage to the ox? Shouldn't the assertion, the ox shouldn't have eaten it, be invoked? And any injury that follows is the responsibility of the ox's owner? And Rava said in response, are you raising a contradiction from a case with permission and applying it against a case without permission? There is no difficulty here, since in the case where the ox's owner brought the ox into the courtyard with permission, the homeowner thereby accepted responsibility upon himself for safeguarding any damage to the other's ox. And even if the ox strangled itself, he would still be liable. Now, here we're talking about animals, and animals either causing damage or being damaged by property of the homeowner when the animal was brought into someone's property either with or without permission. But it just makes me think of a case where, for example, I can imagine a situation where people whose kids are grown, or maybe people who never had kids, have company coming over, and the visitors have little kids, right? So the homeowner, like, it's not in their mind to think, for example, we need to cover up all the outlets, we need to child-proof the cabinets, we need to, safeguard any hazards in the house against what little kids can do, right? Now, parents know that their kids will go and get into stuff. So you would think that if you invite guests to come for lunch and they bring little kids, right, and then the little kids get hurt while they're in your house because it didn't occur to the homeowner that he needed to take special precautions, to protect those little kids, is the homeowner then going to be liable when the kid gets hurt? Maybe that's a situation where the homeowner needs to say, oh, you brought your little kids. They're wonderful. We're so happy you're all here. Listen, the house is not child-proofed. So if you want to bring the kids in, just know that, you're taking the responsibility in case they get into something and get hurt. So absent that statement, have they undertaken that liability or not? We can't learn out the case of kids from the case of animals, or can we, right? On the one hand, you could say, well, a human has agency even if it's a minor. And on the other hand, you could say, but it is a minor, so it's legally, the child does not have legal competence to make decisions. So maybe in this regard, it is treated as an animal. I'm just thinking of this, that case and how it might be analogous. I don't know what the law is in such a case, but, just to sort of stimulate our thinking. Okay, where am I? Right, so Rava said in response, are you raising a contradiction from a case with permission and applying it against a case without permission? There is no difficulty here, says Rava, since in the case where the ox's owner brought the ox into the courtyard with permission, the homeowner thereby accepted responsibility upon himself for safeguarding against any damage to the other's ox. And even if the ox strangled itself, he would still be liable. So at least according to Rava, the invitation, come into my house, implies that the homeowner has undertaken all of that liability, absent some kind of a statement that he's not undertaking that liability. Now, a dilemma was raised before the sages. In a case where the owner of the courtyard accepted upon himself responsibility for safeguarding the items that are entering his premises, then what is the law? Did he accept upon himself only the responsibility of safeguarding himself and his animals from causing damage? Or perhaps he even accepted his responsibility upon himself for safeguarding against all forms of damage that originate from the outside. Now it's starting to feel a little bit more like a paid bailee, right? Like, I just invited you to come in for lunch and you can bring your dog with you. And then the guy says, well, listen, if we come in, I got, the dog is very valuable. Can you guarantee me that no harm will come to the dog while he's here? And the owner of the house says, yeah, sure, there's nothing dangerous here. And then a freak lightning storm comes and the dog is struck by lightning while they're over and sitting in the yard of the homeowner. Is the homeowner now responsibility? Is he now liable for replacing this expensive show dog? That's the question being asked. Let's see. So come in here, a solution based on that which Rav Yehuda Bar Simon taught in the Tractate of Nezikin from the school of Karna. If one brought his produce into a homeowner's courtyard without permission, and an ox came from elsewhere and ate it, he is exempt. But if one brought the produce into the courtyard with permission, he is liable. And the Gemara clarifies, wait, who is the phrase he is exempt and who is liable? Who are we referring to? The owner of the animal that came in with permission or without permission, or the owner of the property that this guest came into? Does it not mean that the owner of the courtyard is exempt and the owner of the courtyard is liable, depending on whether the visitor came with permission or not? This would indicate that by granting permission for the produce to be brought onto his property, he accepts responsibility to safeguard against other damage as well, such as that caused by another ox entering from outside. Not an ox belonging to the homeowner, but somebody else's ox who wandered onto his property. And now, because he allowed the visitor to bring his produce onto his property, he's going to be liable for damage caused by some stranger's ox that also came onto his property during this visit of the one who brought the produce. So in response, they said that this interpretation should be rejected. No. When we say one is exempt or one is liable, we're talking about the owner of the ox that causes damage. He is exempt, or the owner of the ox is liable. And the Gemara asks, but if it is referring to the owner of the ox, what reason is there to rule one way where the produce is brought in with permission, and what reason is there to rule another way when the produce is brought in without permission? With regard to damage done by the ox of a stranger, it should not make any difference, right? Because if the ox did damage not in the public domain, but on someone's private property, then the owner of that ox is liable. And it doesn't matter that the property that was damaged, let's say the produce that was damaged while on the property of some, remember, we've got three parties now. There's the homeowner, there's his guest who brought some produce with him, and that's sitting there on the homeowner's property, and there's an ox that wandered in off the street that belongs to a third person. Now, what difference does it make whether the produce was on the homeowner's property with or without permission if we're talking about the third person, his ox, that wandered onto private property and caused damage? He is going to be liable regardless. We're actually on 48a now, and I'm almost done, so get questions or comments, please get them in. So the sages said in response, if the owner of the produce brought it in with permission, so it is a case of damage under the category of eating in the domain of the injured party. Since, with respect to the produce, the courtyard is treated as belonging to its owner, and the law is that if an animal causes damage categorized as eating in the domain of the injured party, then the ox's owner is liable. But if the owner of the produce brought it into the courtyard without the homeowner's permission, then it is a case of damage under the category of eating in the public domain. And if an animal causes damage categorized as eating in the public domain, the ox's owner is exempt. And given this explanation, the answer to the question of what type of safeguarding the courtyard owner accepted cannot be derived from the Baraisa. So very interesting that according to this analysis, remember we have three parties. Let's say I own the property, Reuven owns the produce, and Shimon owns the ox. So if Reuven brings his produce onto my property without my permission, and Shimon's ox enters my property without my permission and eats Reuven's produce, this is going to be treated as a case of the ox eating the produce in the public domain and not on private property because Reuven came in here without my permission. So it's just like he put down his produce in the public domain where an animal could come along and eat it, because he didn't have any kind of safeguarding for his produce, since he either put it in the public domain or he put it on my property without my permission. Come in here a proof from another Baraisa: if one brought his ox into a homeowner's courtyard without permission, and an ox from elsewhere comes and gores it, he is exempt. But if excuse me. But if he brought it into the courtyard with permission, then he is liable. And the Gemara clarifies who is exempt and who is liable. Is it not the owner of the courtyard who is exempt and the owner of the courtyard who is liable? If so, this proves that the owner of the courtyard accepted responsibility for all damage occurring while the ox is on his premises. And the Gemara responds, no. The owner of the ox that gored is exempt and the owner of the ox that gored is liable. And the Gemara asks, if so, what significance is there to specifying the case with permission or without permission with regard to this ox? For damage categorized as goring, the owner of the animal is liable wherever it happens, whether in the private domain or the public domain. So the sages said in response, So the sages said in response, in accordance with whose opinion is this? It is in accordance with the opinion of Rabbi Tarfon, who says the law of damage categorized as goring in the courtyard of the injured party is different. And the owner of the goring animal pays the full cost of the damage, even if it was an innocuous ox, which if an innocuous ox gores in the public domain, pay half damages. But if an innocuous ox gores on the property of the injured party, full damages. That's according to Rabbi Tarfon. So according to this opinion, the Baraisa should be interpreted as follows. If the injured party brought his ox into the courtyard with permission, it is a case of damage categorized as goring in the property of the injured party, and the owner of the goring animal pays the full cost of the damage. But if he brought it in without permission, it is a case of damage categorized as goring in the public domain, and he pays only half the cost of the damage. That's what I've got for us today. Let's check if I've got a couple of questions. Jonathan, anyone who comes into my domain with my permission is someone whose safety, real and via his property, becomes my responsibility. Right? So Jonathan is saying, yeah, that if you invite him into your property, you have undertaken to be responsible for his safety. And so you would be liable if something goes wrong while he's on your property. Even the lightning strike? Maybe there's a distinction there, right, where its circumstances completely beyond the homeowner's control. But if we're talking about, exposed outlets that a child could stick his finger in, or that, a dog could stick its snout into, then yeah, Jonathan says, yeah, the homeowner did undertake that responsibility. So it sounds like you agree with Rava. Bill, surely the owner has some positive defense in the event of the lightning strike for the dog or the ox from elsewhere, while the phrase is being phased out in favor of more expansive and less colorful terms. when I worked in insurance, we did still have acts of God policies to deal with. Right, so that phrase, interesting, that phrase is being phased out of insurance contracts. But yeah, there was this idea that the insurer will pay, for any kind of liability, any kind of damage incurred. Let's say, in a business property, when there's business insurance for, customers coming onto that property, but there's some kind of an exemption for the insurer when we're talking about acts of God, like an earthquake, right? That's a big deal here in Los Angeles, and there's for sure carve-outs for that kind of thing. Because otherwise the insurer could go bankrupt, if it's insuring a bunch of homes in that area and there's some, kind of freak occurrence that would fall under the legal definition of acts of God. So, we don't know yet how the sages are ruling on this under Torah law, but, we could certainly see the reasoning why you would carve out from standard types of damage that could occur on a person's property versus these freak occurrences, whether the lightning strike or a third party's ox wandering onto the property. And finally, Joseph, there are very good philosophical arguments against the skeptics who demand justice, yet they do not have any real basis for justifying morality or punishment in a worldview absent of the inherent value given by God. Of course, they could push back on this idea, but that would be the debate. Right, and of course, that is, I would say, Joseph, you put your finger right on it, the fundamental question that, let's say people of faith would debate with people, who consider themselves atheists, right? So the atheist who says that this world just is a random occurrence, and so whatever his definition of morality is, it's gonna stem from some kind of social contract, right? That people are going to agree on what morality is, and draft laws and agree to live by those laws based on some kind of mutual definition of what morality is. And of course, such agreement is not easy to come by. Whereas, it's still not so easy to agree. Even people of faith will disagree on what exactly God wants from us. But what they agree on is that God created the world, that God determines what is right and wrong, and that our job is not to invent a definition of right and wrong, but to come to an understanding of what God wants from us, and what is our major basis for understanding what God's will is for us, what God's definition of right and wrong are? The Torah, right? The Torah. God appeared to millions of people at Mount Sinai, sort of one-time event in history, but witnessed by so many that, at least for people who are people of faith, we would say that that was the dispositive event in all of human history. And God did that, even though this is a world that God created for the purpose of hiding God's presence. Right? This world, that's the reason this world exists, where souls can live and interact with each other, and not be certain of exactly what God wants from us at all times, so that they would have free will. So if God created this world as a place where people are free and have free will, are not completely overwhelmed by the presence of God, like everyone is in the world of souls, then why would God reveal himself in this world? Answer: because God wants us to have a code to live by, wants us to know that there is truth and falsity, right and wrong, that God created those values, and we can choose to live by them or not, but we need to know what they are, and that's why God gave us the Torah. That's what I have for us today, and with God's help, we'll be together again tomorrow, Wednesday at the regular time, 6 p.m. Pacific. Have a great